What's up, family? It's your boy King L Bay. Gonna drop some knowledge on y'all, right? We're gonna talk about the due process suite, and we're gonna enter into a series of information. This is the the part one of the series of due process suite. As we get into the understanding what is the due process, so I'm finna try to push this forward and get out here and show you about a lot of stuff. Man, it's I'm gonna break this stuff down from every avenue so that we can have the particulars and understanding what's going on. So we're gonna start with the words, right? Um, I want to start with the word when we start understanding what is due process and what do that mean when we dealing with due process, because we're going to deal with the word abatement, we're going to deal with the word all of that. So let's look at what is due. When we talk about due process, we're going to break this stuff down so you guys can know, so you can do your due process suite and dealing with your court case, and you can know what you need to do. So we're gonna look at what do we mean by having a Bill of Rights? What do all of that mean? These constitutional requisites dealing with constitutional law, right? Which is the highest authority as it relates to this particular government. Treaties is the highest law of the land, but when we're talking about the constitutional fold of government, that is the highest requisite that is required. So let's go to what do they mean by due? That which is owed, what one deserves or entitled to from due, also compared to dues. To give the devil his due, do justice to a person of supposed bad character is from 1590s, right? Do I don't know if this give them their due through they were duels or whatever how you say that. Another under this is um uh, under the second definition of due. This is a noun. This is adjective. It means customary, regular, right, proper. Right? It's right, customary. Right? That means under the Constitution, it is customary that they give you due process of law. They can't get around it. It's right. Right? One of the sayings is that they shall think proper, right? The court say they must think proper in their dealings, right? Owed payable as an obligation on by a right of circumstances, right? It's a right of circumstances or a condition. So when you go to the court and you start talking about that, you're not there to talk about special appearance. You're here on the behalf of the right to settle the matter. And we're here to make a determination by determining the constitutional due process requisites. Before we can speak about me making an appearance, I'm objecting to all things and all matters concerning this situation, right? Or concerning this estate or whatever, right? You are concerning this. So when you go to court, it's not about you going there to make an appearance. It's not about that you going in there arguing with the court, because I'm going to show you under the due process suite what you need to do. When dealing with due process of law, dealing with, I don't think everybody understand what that really means. When we're talking about a bill of rights, a bill of rights in regards to due process. So you're there to settle the matter and to make a determination on the basis if the court has established a claim or not, and that you're here just to settle this matter. You understand what I'm saying? Don't go in there telling me I'm here making a general appearance, because you're not. I'm here through summons, I'm here to determine and settle this claim, or I'm here to dispute, or I'm here to make this. You're not there. I got a manuscript that I have created to show you guys how to deal with the court. Not there telling I'm here for a special appearance. You're not even gonna say I'm here on a non-appearance. I'm just here to settle this. I'm here to settle this matter, Your Honor. I'm just here to settle this matter because I think there is a conflict, and that we need to make a determination based upon due process to determine if this claim can be satisfied or not. And I'm not here to debate with the court, argue with the court. There's just some constitutional requisites that need to be checked off before we can move forward in any of these proceedings. I'm here to object to all things that anything by this court or by the prosecutor until certain determinations or factors have first been discovered. Because you're dealing with discovery. And I'm going to show you why when we understand this information in totality. So, due process is duly from due in reference to the point of compass, directly exact, intestation, originally nautical from notion of fitting rifle. So I'm not going to go through all of this right now. Let's go to bill. Right? What is a bill? It's a formal document, formal plea or charge. Right? So we're talking about a bill of rights. Right? These are things that are obligations that's set on the government. It's an atonement that the government must follow. They cannot subjugate these. They cannot subjugate these constitutional requisites. They cannot change the substantive language in the due process. They cannot change it. This is a violation of substantive constitutional due process requisites. You can't get around it. Y'all going there talking about all of this stuff deals with due process. Making all of this, the nature and the cause, all of this stuff is due process. I don't care what nobody tell you, who you heard it from. It's all due process issues. And if you do not deal with the court accordingly to due process, you're going to lose. It says in a court of law, personal letters, a writing, a list, a seal from medieval, a decree. Due process of law by the Constitution has been decreed. Okay, it says sealed, document, in classical Latin, bubble, boss, stud, amulet for the neck. See bull. The sense of writing statement, detail, article, sold, or service rendered by one to another. That of order addressed to one to pay another. The meaning, papers intended to give public notice of something exhibited in a public place and from late. The sense of paper money, banknote. The meaning of draft of proposed statute presented to a legislation. Right? So that means, okay, Congress and the three branches of government were created from the instrumentality or the instrument called the Constitution. And these Bill of Rights they cannot waiver such Bill of Rights or due process. They are all powerful and they are encumbered within the letter of the law, in which could not be wavered. Now, you can waiver your rights. You can waive such rights, but the government still owe you due process. And what they're doing is they're breaking it down to this and what you don't understand. A Bill of Rights. Billing. So, I'm just going to go through some of this and make this short. I'm going to try to make this fast. Process. So now we're talking about We're talking about Bill of Rights. We talk about due process. What is the process? A fact of being carried on. It's a fact. It's a fact. Why is due process is a fact? Because it's constitutionally legislated and it's embedded in the Constitution, creating a fact of what? Of authority. Citation of authority, meaning that it's factual in nature. They can't get around these facts. This due process requirement or requisite is a requisite. It is required in order for the law to move. Fair to do that, then they fair to state a claim. We'll get into that. We're going to talk about that. It means a journey, a continuation of development, legal trial directly from processes, a going forward, advance, and progress, right? Procedure, go forward. Meaning a course or method of action, continuously action or series of actions or event from medieval century, 14th century, continuous or regular series of actions meant to accomplish some result. Meaning a projection from main body of something, especially a natural appendage. Legal sense, a course of action of a suit at law. The whole of the proceeding in any action at law is attested from early 14th century, hence due process, fair treatment at law, considered as a right. It's a right. It says, verb, being legal action against summons in a court of law, right? Meaning prepare or treat by special process subject to special process from in English of persons to register and examine by 1935 in reference to the U.S. Army related to process or processing. So I need y'all to understand that this is a legal right. They can't get around due process of law. So I'm here, Your Honor. I'm here to settle this matter on behalf of whoever you are. And based on this, that there is a claim that we need to examine before we can move forward. And before I can move forward, Your Honor, we need to make a constitutional determination of the following requisites to determine if jurisdiction has been established. Without this, then the court cannot state a claim in which the relief can be granted. And now we're going to talk about these things, right? Because now without due process, you can put what they call sanctions, right, on the court. It's called constitutional sanctions. So let's go here. Let's go to constitutional sanctions. So let's go here, family. Let me share the screen. Constitutional sanctions. We're going to break in. I'm going to show y'all about all of this stuff, why people are not winning, why you don't understand this stuff. It's constitutional sanctions, right? Sanctions is one element that constitutes the difference between customary and positive written law, whether the concerns the Constitution or any other legal norm. If constitutional sanction is defined as an intervention of an independent and super parts actors such as a court reacting to the violation of constitutional norms with constitutional review, it can be argued that this type of sanction represents the threshold between positive constitutional law and customary constitutional law, which I ain't never heard. Most of y'all don't understand. Positive constitutional law and customary constitutional law. So a lot of y'all are, when you go into court, y'all not putting these constitutional sanctions on there. I'm not here to discuss nothing. First, we need to go over this stuff to make a determination if they got jurisdiction. You're not making an appearance. You're not talking. This is why I'm trying to tell you. So you go in there and you start talking, right? And you ain't putting these questions in front of the court at arraignment. Forget pre-trial, at arraignment. Because we're going to get into some other elements in which I'm going to break down. Y'all are not, y'all going there talking about, oh, what's the nature and cause of the case? Of course, you have the right to a Sixth Amendment nature and cause. But you have a First Amendment right. You have a Fourth Amendment right for persons and properties to be secure. So you got to have where's your security agreement? Where's all your other contracts? I'm gonna show you that deals in your constitutional sanctions, where you can sanction the court when they fail to adhere to the constitutional requisites. So if you go in there and ask for the nature of the action, this falls into a form of discovery issues, dealing still in the Sixth Amendment under violations in which you can sanction the court, in which they fail to do that, then they're failing to state a claim. We'll get into that, and we'll talk about some of this other stuff. Let me stop sharing for this so I continuously break this stuff down so y'all can get the hang of this information, right? Because a lot of people don't know this information in totality, right? We win cases. We don't lose cases. We win cases. We win on these issues, on constitutional issues. I do not argue nothing but due process, family. So we went over the Bill of Rights. Now let's go over the Bill of Rights. Let's go over the Bill of Rights dealing with civil rights, family. Let's go over the Bill of Rights dealing with civil rights. Let's go over the Bill of Rights dealing with civil rights. Right of each citizen to liberty, equality. We're talking about equality, equity. American English from civil in the sense pertaining to citizens and his relations to organized commonwealth or to his fellow citizens, specifically of black U.S. citizens from 1866 in reference to the Civil Rights Bill, an act of Congress which confers citizenship upon all persons born in the United States, not subject of other powers, of every race and color, without regard to any previous condition of slavery. Civil rights movement in reference to drive for racial equality that began in U.S. mid-1950s is attested by 1963. Rarely are we met with the challenge not to our growth or abundance or our welfare or our security, but rather the value and the purposes and the meaning of our beloved nation. The issue of equal rights for Americans, Negroes is such an issue, and should we defeat every enemy, should we double our wealth and conquer the stars and still be unequal to this issue, then we will have failed as a people, as a nation. Lyndon Johnson speech introducing Voting Rights Act March. So I need y'all to understand when we're talking about a Bill of Rights, we're talking about the rights that the government must afford you. They do not get to strip you of such substantive rights and take away such rights to only put you in an inferior position of inferior position to sustain jurisdiction so they can prosecute you and get a victory. That's not how it works. So let's keep going. See, Democratic. So we're going to talk about some of these things and relate to some of that. But hold on, let's go back. Before I get into all of that, I want to talk about abatement. I want to talk about abatement. We're going to talk about the different forms of abatement, right, as it relates to the jurisdiction. A lot of y'all think abatement of common law, there's abatements of claim, right? There's an abatement. So when we look at the word a as it relates to abatement, right, can mean a prefix not, without, right, and not, from pyru, need, not, right? And then you could go down. I want you to look at the etymology of words because black law can be negative, not positive law. It can be negative law, and which you need to understand. So there's different elements of this prefix that you need to look at, and which can mean have different elements in which you can introduce. So I want you to know. So abate. So let's go to right? It can mean not or without. Let's go with pro, right? So I'm doing this to show you the word abate and probate, right? From the element forward, forth, towards the front, proclaim, proceed, right? Prohibit, provide, to take care of, procure, in place of, behalf, Latin, on behalf of, in place of, before, before or for, in exchange for, just, which is also at a first element compounds and had a collateral pour. So, so not, so you got abate, all right? So now let's look up pro as it relates to abate. Let's look up what abate means. Hold on. I know I had bait. Let me see. Let's look up what the word bait means. Let's look up. Okay, let's look up the word bait then. Because I'm going to show you, right, what that means. Bait. It means to suppress, right? It means to do away with, to reduce, to cease, shorten, abate, right? So when you say something, right, to suppress, to do away with. So when you abate something, you're doing away with it. Now, I want you to understand when you probate, right, it says to contend with blows or argument, right? So when we look at the word probate, right, it says to beat, to knock, to hit. So let's go back. So abate means to do away with. Now let's look back to the word pro again, right? It means a consideration or argument in favor. So you're going to argue, right? And then it's an argument, and now you talking about bait, right? Right? To blow. So to probate is to mean to place your estate, to probate someone to the state is someone to argue and beat or argue for your estate. We're talking about probating your estate. Abating your estate is to do away with. So let's get into abatements. Abatements of a claim. Family, let's get into what we call abating a claim. Abating a claim. So you got abatement at common law, but let's get into abatement of a claim. An abatement of a claim is to interruption of a legal procedure. It occurs when a defendant raises a matter that prevents the plaintiff from proceeding with a lawsuit at the time or in the form. It can be considered a defense. So we're talking about abatements, right? Of what? You can do abatement of property, abatement of nuisance, abatement of rent, abatement of taxes, and abatement of suit. You got abatements of legacies, right? So let's go here. Abatement of let me see if y'all can see this. Let me stop sharing. Let's go to abatement of legacies, right? Let's go to this. A lot of y'all don't, when y'all hear a word, y'all be thinking somebody say do abatement of common law. No, we're dealing with Admiralty Maritime. So abatement of debts and legacy is a common law doctrine of wills that holds when that equitable assets of a deceased person are not sufficient to satisfy fully all the creditors, their debts must be abated proportionately, and they must accept as divided, right? So when we're talking about abatement of legacy, we talking about abatement of a claim. When we're talking about the abatement of your estate, rights of the estate, y'all need to understand this. And I'm gonna do a series on the due process week. I'm gonna do a series on the trust. We're gonna just start breaking this stuff down because it's too many people giving y'all too many wayward thought process, and they don't know how to win the claim. They don't know how to get you when they talk about equitable relief, right? So let's go to all of this, right? Abatement of a claim. I'm about to. So I talked about. Let's talk about adhering to the Constitution, right? So let's talk about a right to be heard, a constitutional right. So you're just here to be heard. When you go to court, you're not here to make an appearance. You're just here to be heard on the matter. You're there to be heard to create a record to determine if the court got jurisdiction or not. Based on the constitutional requisites that's been laid before the state or the federal government meet each and every constitutional requisite to before they can make a determination, because we're going to deal in contract law. And really, this is where nationality come in very important, because nationality dealing in statehood, dealing with the rights of nations. We'll get into that as I break this down through these series. This is why nationality come important, because we're talking about rights of nations through treaty rights. We talk about breach of treaty. So we'll get into all of that as we break this down through this series, because I'm going to do a series on all of this information to show you guys how to confer and think as a litigator. It says a right to be heard. I want you to understand the right to hearing is a constitutional right that resides in both the Sixth Amendment as well as the 14th Amendment. It entails that an individual maintain to be afforded the right to be heard in the venue of a court of law with adequate due process attachments. I want y'all to, it says adequate due process attachments, right? The Fifth Amendment of the U.S. Constitution guarantees the right of due process of law. The right to be heard means the public authority must listen to an individual before making a decision that affects his or her rights or interests. The court must listen. I want y'all to understand that. The court got to listen, right? Right? So I want y'all to understand this, right? So when we're talking about these constitutional requisites, as you guys need to understand this due process suite, this is how I win cases. That's all I deal in due process suites. I don't deal in nothing else. I don't deal in nothing else but due process, right? We don't deal in nothing. So um we're gonna talk about libel and we're gonna talk about what they call known or should have known in every case, right? So we're gonna talk about these things, right? So we're talking about, right, abatements of your, and then we're gonna talk about your constitutional right to be heard, right? And I wasn't sharing the screen, so all we do is win cases. I barely, it's hard to lose based on your understanding of constitutionality and the framework on due process issues. And I'm gonna show you at arraignment, we're not doing none of this stuff going in there. We're not gonna let us railroad. And I'm gonna tell you what we're gonna do. We're gonna hit them with injunction relief. But let's get back to this. So the Fifth Amendment of the Constitution, um, right, guaranteed the right of due process. The right to be heard means that the public authority must listen to an individual before making a decision that affects his or her rights or interests. It means, so I want you to understand, rights are different from interests. It also means that a person should have an opportunity to submit facts, arguments, evidence before a decision is made. So we're talking about the court establishing jurisdiction. If they don't meet the constitutional requisites, right, which I showed you, we're talking about customary constitutional law and customary or constitutional. Let's go back. Let's go back. Customary constitutional law, right? Let's go back. Let's go back. Let me show y'all again. Customary constitutional law. And I told you we can hit them with constitutional sanctions. Constitutional sanctions is the one element that constitutes the difference between customary and positive written law, whether it concerns the Constitution or any other legal norm. If the Constitution's sanction is defined as an intervention of an independent and super parts actor, such as a court, reacting to the violation of written constitutional norms with constitutional review, it can be argued that this type of sanction represents the threshold between positive constitutional law and customary constitutional law. If you guys don't know this stuff as it relates to due process and you don't hit these courts with this, you're going to lose. So let me show you one of the remedies that I do when the court at arraignment, as we talking about due process violations, abatement, we talking about slander, libel, making a claim, making a false claim. So when you ask for the nature of an action and the prosecution do not know, it falls under what they call known or should have known, right? Knowingly. The term knowingly with respect to conduct as a circumstances or a result means that a person has actual knowledge or should have known of the conduct, the circumstances, or the result. So when we're talking about known or should have known as it relates to the constitutional matter, the prosecutor, the state prosecutor attorney, the state general know or should have known these constitutional requisites. They cannot get around this. If they don't understand constitutional law, ignorance of the law is no excuse. That has nothing to do with you. So what do you do when the state known or should have known and you know how to argue due process under your due process suite? We get this together. So let's go. We hit them with an injunction for equitable relief. Here with an injunction. I put injection. Equitable relief is distinguished from remedy from legal action in that instead of seeking merely monetary damages, the plaintiff is seeking that the court compels the defendant to perform a certain act or refrain from pertaining a certain act. Common types of equitable reliefs are specific or equitable reliefs or injunctions or specific performance or back chores. So we're gonna get this done. So an injunction is equitable relief. So what happens, right? A vacatur is a legal term for setting aside a judgment or conviction. It is also a form of relief by victims of trafficking who were coerced into criminal activity by their traffickers. A, a vacatur law can help survivors rebuild their lives by removing the barriers and stigmas of criminal records. So I want to it's to vacate a motion to vacate judgment, right? Motion to vacate is another form of equitable relief, right? So, but we're gonna hit them with an injunction. So, why would you hit a court at arraignment for an injunction? Put them notice of injunction. Let's break some style. An injunction is a court order requiring an individual to do or omit doing a specific action. So, violating due process is a no-go. You just got to know what you're doing with this family. When we're talking about the abatements, right? Probate, I want y'all to understand probate, abate, when you telling them no, they cannot, they don't have the right to your estate. They haven't been given authority or permission to adjudicate the estates. When you understand due process of law and you understand what is the process, you stop all the nonsense. So when I go in there, I already got it scripted. I already know what I'm gonna write. I'm here not to make a special appearance. I'm just here to be heard on this matter to settle this claim. Before we can move forward, Your Honor, I want to ask this court several questions to make a legal determination before we can proceed in any of this matter. And this is dealing with certain constitutional requisites. May I begin and address the court before we can establish any kind of suit and any kind of suit, and before the court can determine if jurisdiction has been properly established. That's what you go in there and do. You don't go in there and start talking about special. Leave all that stuff alone. You go down there and you kick their butt because they know when you hit them with the nature and cause, and if the prosecutor say he don't know what the nature is, right? You ask the court, could I sanction this court under constitutional grounds that the prosecutor failed to state a claim for relief to be granted? And I'm asking that this case be dismissed with prejudice on such grounds. And if the court want to argue with me on this, I'm here to inform the court of a notice of an injunction for these due process violations. Period. You get the case knocked out the park. Dealing with due process issues. Due process. I don't argue nothing but due process. And where did I get it? I got it from a case law that I was reading years ago. And the case law explained the court is only to offer due process. It's not to determine your innocence and guilt. It has nothing to do with your innocence and guilt. It says they know, this said in the court, in the Supreme Court opinion, it says ain't no innocent people are in jail. But that has nothing to do with the court. They just there to give you due process. Your innocence and guilt was based on the jury. Either the judge is acting as juror or the jury of your peers determined your fate. The court of Supreme Court, I forgot the case law. It's somewhere in my files, in my records, but I used to go to the law library and I came across that case. It says the court only extends due process. And from there, I realized I do not argue nothing else but due process issues, period. When I'm on appeal, I'm hitting them with substantive or procedural due process, dealing with the constructive language of the Constitution based on citations of authority, dealing with either Brady of all of these different things. So I already broke down what are some of your elements that you need to do, right? What are we talking about? What are we talking about when we're talking about due process of law? Right? So I'm about to get out of here, family. All we do is win in this court issues, and we're going to break this down. Check out the series on the due process suite. We killing them with due process. That's how we argue is due process. I don't go. I'm telling you, the due process has not failed me now yet. It has not failed me. So peace and love, everybody. I'm telling you, due process. If you understand this due process, you will not. It will not fail. Peace.